Wagwan people, welcome back again to another video, the Jamaican guide here. Today we will be looking at how to get a divorce in Jamaica, and we are gonna get right down right now. People, so oftentimes a lot of people get themselves into some situations, and guess what? Some of the times them only did a focus on how to get into these situations and not how to get out. Need to do to get out. All of that. Me know say as so no stay, I come for save the day. So mama gonna know what uno need for do if uno ready, when uno ready, or if uno go ever ready. Okay, so let me just define what a divorce is. A divorce refers to the legal termination of a marriage, and with it, there may be consequences for how property is divided, how maintenance is to be paid to either spouse, and custody and access in respect of any relevant children. A divorce is often portrayed in television shows as filing papers, and to some extent, it can be as simple as that. Okay, so who can apply for a divorce in Jamaica? You would have to be a Jamaican national. You are domiciled in Jamaica at the commencement of the proceedings, or you reside in Jamaica and have done so for at least 12 months immediately preceding the commencement of the proceeding. All right. So, a divorce will be granted on these bases in Jamaica. The parties must first be separated for a continuous period of 12 months, notwithstanding attempts to notwithstanding attempts at reconciliation. The parties could still be viewed as separated even if they continue to cohabit the same dwelling. For example, if the spouses sleep in separate bedrooms, or cease to engage in sexual relations, or cease to carry out household duties such as washing, cleaning, or cooking on their spouse's behalf. There are special considerations for marriages of less than 2 years, and there are additional requirements where children are involved. A court will not make any orders in relation to any application for dissolution of marriage unless it is satisfied that adequate arrangements are in place for any relevant child. The only ground for granting a divorce is an irretrievable breakdown in the marriage. If there are no children and no dispute as it relates to maintenance or property distribution, the process of a divorce can be seamless. Okay, so I'll be giving you the 4 legal steps every person has to go through to pull this off. Okay? Step 1, filing the petition. The petition is the document which speaks to the history of the marriage and the reason for separation. Once the petition is drafted and filed at the Supreme Court, it is reviewed by the Registrar of the Supreme Court, who then certifies that it is a true copy and affixes the court's seal. This certified true copy of the petition is then returned to your attorney for service on your spouse. Step 2. Service of the true copy of the petition. The petition must now be served on your spouse. A process server is retained and the document is served on him or her on your instructions. Your spouse has 14 days from the date of service to respond to the petition by filing an acknowledgement of service in which the divorce is either contested or not. If the divorce is contested, a date will have to be fixed for a hearing, and the petition may have to prove all the facts set out in the petition, including the fact of separation, and that there is no possibility of resuming cohabitation. If your spouse indicates that he or she is not contesting the divorce in the acknowledgement of service, then you may proceed to step number 3. If 14 days have passed since the true copy of the petition has been served on your spouse, and your spouse has not filed an acknowledgement of service or any other document in response to the petition, you may still proceed to step number 3. All right. Step 3. Applying for a decree nisi. 14 days after the petition has been served on your spouse in Jamaica, different timelines apply for a service which takes place outside of Jamaica. Provided there has been no challenge to the proceedings, the petitioner may apply to the court for a decree nisi, which is the first indicative order of the dissolution of the marriage. This application may be heard on paper and as such does not require the parties to attend court. Fourth and final step, applying for decree absolute. 6 weeks after decree nisi is granted, the petitioner may apply for the final order in the divorce proceedings, the decree absolute. This application is also considered on paper without the need for attendance at a hearing by the parties. This is the final stage in the dissolution of the marriage, and the decree absolute is proof to the world that your marriage has been resolved. Okay, so notwithstanding the ease of the process outlined, each divorce is unique, and through consultation with your attorney, you can again be advised on how to best treat with any auxiliary matters that may arise. These auxiliary matters may include custody, maintenance for children and spouse, and or property distribution. So that's it, guys. Hope this video is of use to some of you. So until next time, stay safe.